Testing?
Testing 1, 2, 3.
Testing? Mic check, mic check, mic check. Good? All right.
One, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3. Checking 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yeah, you hear good. Okay.
The Subcommittee on Regulatory Reform, Commercial and Antitrust Law will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time, and that's going to take place in about 30 minutes, 30 to 40 minutes, because we will be voting. Welcome to this hearing entitled Assessing the Obama Years, OIRA, and Regulatory Impacts on Jobs, Wages, and Economic Recovery. This topic is of the highest importance to working Americans. The last recession ended in 2009, but the economy has been limping along ever since. Job growth has been weak. Households' incomes have stayed put. The economy has not grown by more than 3% in any of these years. One clear contributor is the growing federal regulatory burden. Under the Obama administration, the number of major regulations promulgated per year has increased dramatically. In 2015, federal regulations imposed an estimated cost of $1.89 trillion. It's loose. Okay. That's all right. To put this in perspective, U.S. regulatory costs now exceed the gross domestic product of both Australia and Canada. Numerous studies and the agencies themselves concede that on an industry-specific level, regulations lead to job losses. At a minimum, the data also establishes probable cause for concern that regulations decrease employment in the aggregate. Data shows that even where workers in regulated industries find new jobs, the displacement triggers a lifetime of physical and economic problems. Accordingly, as President Obama's former OIRA administrator, Cass Sustain, said, regulators must take that possibility seriously. Unfortunately, regulators are not following this prudent path. A recent study of agencies' regulatory impact analysis found that only approximately 20% qualified employment effects. Since 2009, the Obama administration has imposed 229 major regulations at a cost, by its own estimate, of $108 billion annually. Merely administrating regulations in 2015 was estimated to cost taxpayers over $57 billion, an 83% increase over 2001. The effects are dire. A September 2015 study by a Princeton Nobel laureate shows shocking rising mortality among blue-collar segments of society. According to the study's author, those are the people who have really been hammered by the economic malaise. Their wages in real terms have been going down. The economic stress is leading to drug and alcohol dependency and death, mental health problems, and even suicide. The administration is dismissive. It circumvents reasonable procedures designed to limit burdensome regulations. It uses technical gimmicks to claim speculative benefits outweigh regulatory cost. Delegations of power are read broadly, while limitations are read narrowly. Half of the administration's vetoes have been used to block congressional objections to controversial regulations. OIRA is supposed to be the gatekeeper, the entity that helps fight overregulation and protect small businesses and the American worker. Unfortunately, on some of the most costly and controversial regulations of the last 8 years, OIRA has not proven an effective check. For example, it never insisted upon the required small business impact analysis for EPA's Waters of the United States regulation, despite its obvious sweeping reach. Nor has it questioned agencies' excessive reliance on co-benefits, and performing required cost-benefit analysis. In fact, one of the reasons agencies have to inflate the claimed benefit of their rules is to outweigh skyrocketing costs because they are regulating well into the region of diminishing marginal returns, where one must spend increasingly more to achieve increasingly less. This track record makes me concerned about midnight rules at the end of this administration. Midnight regulations impose the ongoing administration's agenda on the country before an incoming administration can stop it. So today it is important to ask, what serious steps will OIRA take to prevent this final abuse? The legacy of this administration will be severe damage to hardworking Americans, our economy, and the rule of law. Discretion afforded to administrative agencies by Congress has been abused. Major decisions were made not by the people's representatives in Congress, but by unelected bureaucrats. This cannot stand. I hope the Administrator Zielinski can offer ideas on making OIRA more effective. I also hope to hear from our second panel witnesses about needed reforms. The chair now recognizes the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, the gentleman from Georgia, Congressman Johnson, for his opening statement.
I thank the chairman. It's on. I thank the chairman. Established by the Paperwork Reduction Act of 1980 and empowered with centralized regulatory review responsibilities under President Reagan, the Office of Information and Regulatory Affairs, also known as OIRA, functions as the gatekeeper of the regulatory system for the most important federal rules. In 1993, President Clinton issued Executive Order 12866 to require that OIRA review all, quote, significant, end quote, regulatory actions between 500 and 700 a year. It additionally requires that federal agencies prepare a cost-benefit analysis for economically significant rules. In January 2011, President Obama issued Executive Order 13563, which reaffirmed the principles of Executive Order 12866, but also requires that agencies develop plans for retrospective review of existing regulations to determine whether any should be modified, streamlined, expanded, or repealed. And finally, the Obama administration issued Executive Order 13610 in May 2012 to further increase public participation in retrospective reviews. According to Mr. Shalansky's predecessor, Cass Sunstein, these orders have energized agencies to identify hundreds of outdated rules for elimination, and many agencies have already finalized or proposed or formally proposed over 100 of these reforms. For instance, the Department of Health and Human Services has finalized several rules to remove hospital and healthcare reporting requirements, saving $5 billion over 5 years. These efforts have continued under Administrator Shalansky and thus far appear to be working. Combined, it's clear that these initiatives have already resulted in hundreds of formal proposals to eliminate rules, representing billions of dollars in savings over the next several years and substantially more in eventual savings. I look forward to learning about the continuing efforts to date of the President's push to have agencies improve and modernize the existing regulatory system. In addition to conducting oversight of OIRA, witnesses on our second panel will also discuss larger concerns with our nation's regulatory system. I would note that the most pressing issue facing our regulatory system today is the timely response to public health and safety crises through the expeditious promulgation of federal rules. But sadly, it has become common for my colleagues to assert that the same regulations that protect our health, safety, environment, and our financial system have undermined the nation's economic recovery and job growth. This could not be further from the truth and is simply not borne out by any serious research. Perhaps that's why conservatives also acknowledge that in light of improvements in the economy and the unemployment rate, it is becoming increasingly difficult to argue that the current regulatory environment has any effect on jobs or growth. Douglas Holtz Eakin, one of the majority's witnesses in today's hearing, commented last year that, quote, with low unemployment and rising wages, the Republicans' job gets a lot harder, end quote, while also referring to recent employment growth as promising. I think 20-some million new jobs created over in the private sector since President Obama took office, versus a loss of a couple million jobs during the previous administration. And with respect to those figures about rising mortality rates among the blue-collar working group demographic, it's not just because wages have gone down and they're dying because of alcohol, drugs, and mental health. Certainly wages have gone down and they are dying of alcohol, drugs, and mental health disease, but also liver and heart disease are taking out our fellow man. And this can all be attributable somewhat to the globalization of our economy, the movement of jobs offshore, production jobs, blue-collar jobs. Those jobs, many of those jobs have left under trade deals that have not worked for the American worker. And people, unfortunately, there's a sense of hopelessness that starts to pervade their thinking, then they turn to alcohol and drugs, and they then develop liver disease, heart disease. But fortunately, there's treatment available for the millions, tens of millions who have been able to gain access to the healthcare system due to the passage and implementation of the Affordable Care Act, which my colleagues on the other side have tried more than 60 times to abolish with no plan in place to replace it. And of course, we've had some regulations that have ensued as a result of implementation of the Affordable Care Act, a major piece of legislation, and also the Dodd-Frank financial reform bill that has attempted or has been effective thus far at creating another or enabling another too big to fail situation to take out the retirement earnings of our working people and to keep our economy moving forward. So I would like to say that once you set aside anti-regulatory rhetoric, it's clear that regulated industries exhibit more entrepreneurship, competition, and innovation, given the fact that Alex Tabarrok, an economics chair at the Mercatus Center at George Mason, found in a 2015 study that industries with greater regulatory stringency, and I'm quoting him, have higher startup rates, as well as similarly high job creation rates. So in closing, I'd like to thank Administrator Shalansky for taking the time to appear before us today. And I'd like to thank the other witnesses for being here today, and with that, I yield back.
The chair now recognizes the gentleman of the full Judiciary Committee, Mr. Bob Goodlatte of Virginia, for his opening statement.
Thank you very much, Mr. Chairman. I want to thank you for holding this hearing, which is very timely. overregulation is not a new issue, and the reason why this hearing is timely is it comes right after Independence Day. Among the grievances that the signers of the Declaration of Independence lodged against King George was overregulation, and I quote, "He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance," end quote. Unfortunately, the problem has resurfaced. Last year, employment at regulatory agencies hit an all-time high of 277,000. In 2014, rules from the administrative agencies outnumbered laws passed by Congress 16-1. There's been a dramatic power shift in these United States from elected officials to unaccountable bureaucrats at federal regulatory agencies. In theory, agencies are governed by legislation like the Administrative Procedure Act, as well as executive orders designed to ensure transparent, quality rulemaking that is responsive to the people, balances costs and benefits, and is faithful to the intent of Congress. In practice, though, too many administrations have not adhered to these procedures in good faith. The Obama administration in particular has taken advantage of the system to ram through radical, controversial, and sweeping policy changes contrary to the will of Congress and the views of large segments of the voting public. Serious reforms are needed to curb these abuses. At key stages in the rulemaking process, the administration has ignored or subverted common sense rulemaking procedures that stood in the way of their policy goals. For example, instead of using required regulatory impact analysis to determine whether regulation is necessary, agencies produce them in a perfunctory way after the decision to regulate has already been made. A Mercatus Center study found that in essentially 87% of cases, agencies embarked on costly regulations without significant evidence that there was a problem or a precise idea of what they needed to fix. Similarly, agencies make questionable certifications that rules will not have a significant economic impact on a substantial number of small entities in order to avoid requirements designed to help rein in impacts on small businesses. While the Obama administration pays lip service to the virtues of cost-benefit analysis, it routinely uses technical gimmicks like non-standard discount rates and excessive reliance on co-benefits to ensure its preferred outcomes. The administration is also exploiting the Administrative Procedures Act's interpretive rules exception to impose dramatic and controversial policy changes without notice and comment or public participation. These include an unprecedented 30 guidance documents from the Department of Education straining the application of civil rights laws into controversial areas well beyond their intended scope. Unfortunately, whether with regard to highly controversial rules like EPA's Waters of the United States rule, Clean Power Plan rules, or Utility MACT rule, the Office of Information and Regulatory Affairs, OIRA, has proven ineffective at preventing regulatory abuses, particularly when the costs are highest and it matters most. To be sure, in some cases, OIRA has improved the quality of rulemaking. However, that just underscores the need for fundamental regulatory reform in the face of executive branch abuses in the most high-profile cases. This hearing is an opportunity to lay before the American public precisely how the President's "I have got a pen" approach has exploited the weaknesses in the regulatory system. That is the legacy of the Obama administration. For 8 years, it has abused discretion that Congress delegated in good faith. Serious and comprehensive reform is needed, and I look forward to exploring with the witnesses both the problem and its solutions. Thank you, Mr. Chairman.
The chair recognizes the full Judiciary Committee ranking member, the gentleman from Michigan, Congressman Conyers, for his opening statement.
Thank you, Mr. Chairman, members of the committee, and especially to our first witness, the head of the Office of Information and Regulatory Affairs. It's been 3 years since Administrator Shalansky was appointed to head OIRA, and I'd appreciate hearing his thoughts on the current state of affairs with respect to federal rulemaking and whether legislative fixes are needed in his view. And I'm also, I don't know how you can get all this into 5 minutes, but I wanted to get a sense of what it was like before you took over, so we can empathize with what it is you've been working on and how you've approached it. Some think the regulatory system, as you've heard, is broken. But to that end, excuse me, they also support a series of anti-regulatory measures, many of which would impose numerous procedural burdens on federal agencies. Now, that's a curious difference of views that are being pushed by some of the same important personalities in the Congress. Other anti-regulatory measures would upend the rulemaking process through unnecessary and costly litigation changes. For example, one bill, 4768, Separation Powers Restoration Act, is likely to be considered on the floor later this month and would require federal courts to review all agency rulemaking and interpretation of statutes on a de novo basis, resulting, of course, in a paralysis that would be out of sight. It's probably impossible from my point of view. And so there's a sort of a opportunity to press down on OIRA and its leadership, which I've had some indication that they are small and understaffed and with this enormous responsibility. And I'd like to get from this hearing, not only from the administrator but the panels that follow, an idea of how we in the Congress can make the process more efficient, and how the administration can make it more efficient without Congress intervening, if that is possible. And that's why the hearing's important. The government has the obligation to protect health, welfare, and safety of all our citizens with a need to foster economic growth. And so it's in that spirit that I come to this hearing to hear our administrator describe how things work inside OIRA and what the challenges are that you are faced with. We know that the period of time for regulation is getting pretty long, and we want you to candidly tell us what you can do about it and what we should do about it. And so I thank Chairman Marino for holding this hearing, and like my colleague Mr. Johnson, I look forward to the work product of this important coming together. Thank you, Mr. Chairman.
Without objection, other members' opening statements will be made part of the record. Before we break for voting, I'd like to swear you in, sir, if you don't mind. So would you please stand and raise your right hand? Administrator Solansky, do you swear that the testimony you're about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? I do so swear. Let the record reflect that the witness has responded in the affirmative. And thank you. Please be seated. We're going to head to vote now. We have 5 votes. They're beginning out with a 15-minute vote and then 4 5-minute votes, so it looks like we're looking at pretty close to at least a half hour. And I apologize for that, but we will get back as soon as possible, sir.
heard the song Black and White. It's actually a really good song. Yeah. It sounds like Maroon 5 wrote this song. Where did Megan go? The antitrust one? What? Oh, public safety. Oh, okay, okay. Andrew and I made a press list and did some practice LSAT problems. That was all we did. No, it's okay. I finished it. You did practice questions? Practice LSAT questions. Only logic, because the rest of the stuff is logic. Yeah. I don't know what you're talking about. It's like fun challenges. They're difficult. I just need to keep practicing them to figure out like the patterns. Yeah. Once there's only like 20 styles of questions, and then they're just to know it, you just get really good at it. Yeah. I'm gonna start studying now. Okay, it took me like 30 minutes to do 6 questions. I was like, what the fuck? Why is this taking so long? I had so many LSAT books, and I tried to like sell them back after, and then they come out with a new one every year. So then I was like, should ask them about buyback programs. That's what I remember. This was when my parents had been in Australia for 4 years. The shooting Let's not buy one of those stupid jets that we're never gonna fly for the military. Exactly. No vibe. Although it's not pop. The reason it worked so easily in Australia is because there were already such stringent monitoring for just guns. You can't gun show loophole and shit like that. That didn't exist. Doesn't exist. I think you're underestimating the number of crazy conservatives that would never give their guns to the government. Yeah. Seriously. Although I will say it is very fun to shoot a gun in other countries. Going around nobody
with a gun
trying
would
to
scare me.
shoot. What are those disc things? Shop shooting, there you go. Yeah. I would do that. That seems fun. Wait, have you done it before? No. Have you shot him at all? No. Never shot a gun. I know too many people who died at a shooting range. Like, I'm not opposed to shooting. Recreationally shooting. I tried recreationally shooting once, and I fired one shot and then handed it to my boyfriend, and he walked away like that, and I called my dad.
Oh,
They're scary. And they push back a lot. Yeah.
what was your like emotional reaction to it?
Oh my God, I'm Mr. Jeffries right now. Okay. I don't know if I well, because no one in my family or no one that I know is a gun advocate, gun owner, gun enthusiast. So I've literally only been raised and educated listening to them as something bad. So when I did it, it just scared me, and I didn't like having it. Yeah. I know a woman named Jana who owns 5 guns. It's just she's from Montana. It's just a normal thing. Yeah. And also people in Montana don't shoot people. They don't really shoot people. It's just their culture over time. Yeah. My dad brought that gun to my when I was a little kid. Really? Wow. Yeah. So he's not even against guns. He's one of those Republicans that fights against his interests and just believes things that Republicans say all the time. And I'm like, yeah, demagoguery is so fun. We should actually go back to bayonets. And then drop it. Yeah. Or I thought it was a bang, or I mean whatever it is. He just shoots one thing and then spends
Yeah.
the next time
Guys,
putting guns.
very unrelated. New York City lost its America's Rudest City title.
We lost what?
Your title of America's Rudest City to Miami this
Oh,
year.
I'm actually quite happy with that.
I'm 0% surprised. Huh?
Nikita met Megan. Changed the list.
Yes. Yeah, this is someone's job.
Wait,
It's really the worst city in the world.
you slash what source wrote this?
I've seen articles from, there are a bunch on my newsfeed right now because everyone's like, oh my god, yay, Miami. NBC Miami is reporting on it. I will click on it to see the source. It's just like one of the really unique things about Miami you'll see is like, this is the most concrete example of like why it's such a flashy city and it's a very shallow city. Like, you will see 70,000 cars parked in front of homes that are falling down. Like, people would rather other people think that they're rich than like provide a home for their family that is nice. Like, it's like that's just the mindset.
That's
in Miami.
also a very Hispanic slash
That too.
immigrant mindset.
Yeah, it is.
Yeah.
And that like certainly has some influence, and that collides with like a culture that already exists in Miami of like the Americans that are there. That's very flashy and very showy, and Miami has no historic value. It's everything. Yeah, it's like it's a party city. There's no cultural value. It's like there's
All these ugly stucco buildings.
yeah, it's really
Yeah,
ugly.
really, it's really gross.
Travel and Leisure magazine.
What's the name of that one street where you go down and all the hotels are there?
Oh, that's on Miami Beach. That's like off
the
Ocean
name of it.
Drive.
Ocean Drive, yeah.
Yeah.
We stayed at the W. Just beautiful hotel.
That's the most beautiful street also in
Really
Miami.
nice, yeah.
Have you guys had a rooftop bar in the W before?
We should go. Just kidding.
Well, we could probably go there and you can have, maybe we could get a snack or something. But it's like,
Yeah, no, we could. We definitely could.
I feel like they would know what a real New York idea looks like.
it's not to make a wish list for us. I know, we're running out of time, you guys.
What time do you guys think this hearing will be over, by the way?
Maybe by like 5 or something.
I'm gonna leave at 5.
I have to leave at 5 because I have a gym class at 5:45. Oh, to drop off that thing.
Nope.
Oh, yeah.
Yeah. It's gonna be. It's like a 2-mile trek.
It's also, don't they close? Remember we tried to go like
Oh shit! It
5:30 and
closes. Yes. I don't know, but we got there.
the
Like,
White
we
River one?
got there at 5:05 or something. And it was closed.
Oh, that's beautiful.
Did you take that? Or?
I went. I went with my boyfriend. A glass of champagne.
Oh my gosh, we should do a girl date.
Yeah, we should. It's really fun. Are you gonna go out of town this weekend?
I don't know, maybe.
We have a girls' day, but just a bunch of different friends.
Yeah.
Capital Bike Share is free this weekend.
I know. I saw that.
Friday, I think.
Yes.
Oh.
It's only like
We're very scary. Let me just switch this to the left. Caitlin is completely oblivious to this whole conversation. I can hear you, but I can't. Caitlin, we're married. Is what you get.
Does anybody want to go to a briefing with ice cream tomorrow?
Yep.
Yes.
On why homicide rates are rising?
So long as it doesn't overlap with ice cream.
Talk about murder and ice cream.
Those are my two favorite things. No, I just want to go to the FBI thing. Yeah. As long as it doesn't
Honestly, one of my favorite episodes ever of Law and Order was when this guy was murdered in a ice cream store.
Wow, your two favorite things, Nikita, murder and ice cream.
But it was actually a very sad moment for me when Cold Stone became unprofitable. And I think it's been pulled apart.
Very sad.
Free Cold Stone for everyone.
Mischief managed.
Caitlin, do you think tomorrow that someone will be able to go watch Representative Jacob's Gillette, Director Comey?
Yeah, that is totally up Aaron's alley. But then you have to clear it with Roz, obviously.
Yeah.
So
Okay.
I did not speak for her.
I think she'll
I was
intense.
so scared this morning when she wanted me to go like run something.
Yeah, I
over
sensed
there.
that. I was like, hey, here are other interns. And I think you can see this one. The other ones are real. They're real. So I'd like, I
We're
had
nothing
her.
but aberrations, actually. Me and Andrew
If you're upstairs, you
no
don't
longer
exist.
exist.
I totally understand. I worked with that. I was,
Shadon doesn't know.
you know what the
half
nickname
this
is for it?
exists.
The Stacks or Les Mis? Because the bookshelf.
I heard Siberia.
Yeah.
No, that's like the old nickname for B336. Or I guess Old Forward. But now that the majority of us are over here, it's not like a gulag anymore.
Right.
It's
Oh, Andrew and I tried to get into the meeting that Aaron sent us to.
Didn't work.
So we got to the door and they're like, you actually have to wait 15 minutes. So we walked away, but before we did, we took all these mints that they had. And they didn't even take the lid off. So we had to go back to Ford and pry it off. It was the worst.
Oh,
Hey, y'all
Mic check. Oh. No problem. Mic check, mic check, mic check for the court reporter. Mic check, mic check. 1 2 1 2 1 2 3.
That's what he said something about an intern looking like a sheriff. And I was like, what are you talking?
The hearing will now come to order and resume. I will now introduce our esteemed witness. And thank you. I apologize again for making you wait. Dr. Howard Shelinski was confirmed by the United States Senate in June 2013 as the administrator of the Office of Information and Regulatory Affairs, otherwise known as OIRA. Prior to his confirmation, Administrator Shelinski served as the director of the FTC's Bureau of Economics and as chief economist for the Federal Communications Commission. Administrator Shelinski also served as senior economist for the President's Council for Economic Advisors. Prior to working for the government, Administrator Shelinski practiced law and taught at both Georgetown University and the University of California at Berkeley. He received his BA from Haverford College and his JD and PhD in economics from the University of California at Berkeley. Following law school, he clerked first at the district and appellate courts level, and then for Justice Antonin Scalia on the U.S. Supreme Court. The witness's written statements will be entered into the record in its entirety. And I ask, sir, that you've been here before, you know how it works. Now, because we're not in the original room, we have no lights, we don't even have a timer. Somebody's going to sit beside me and tap me on the shoulders. And when you get it about 4.5 minutes, I'll just diplomatically hold the hammer up. I will not hit anything or anyone, and just try to wrap up that in the next 30 seconds to a minute. So, Administrator Shelinski, please.
Thank you very much, Chairman Marino, Ranking Member Johnson, and members of the committee for the invitation to appear before you today. I am pleased to have this opportunity to discuss recent developments at the Office of Information and Regulatory Affairs, OIRA, and report on the progress OIRA has made on the key priorities I outlined when I first appeared before this committee in July of 2013. OIRA has a broad portfolio, but one of our main duties is to coordinate the review of significant regulations. The basic principles of regulatory development and centralized review have evolved in a bipartisan way over the course of the last few decades. The structure of regulatory review that we follow today was established by Executive Order 12866, which is quite simple and straightforward. Regulations should be based on a sound analysis of their impacts. They should be developed with public input and subjected to public scrutiny before they are finalized. And they should be reviewed by a central office to ensure consistency with sound regulatory practice and administration priorities. OIRA does not review all executive branch regulations, nor would it be efficient for the office to do so. We review only significant regulatory actions. The most fundamental category of significant regulations are those that are economically significant, the threshold for which, under the executive order, is an annual effect on the economy of $100 million or more. Typically, an agency sends a draft of a significant proposed or final rule to OIRA, after which OIRA coordinates an interagency review process. Typically, the agency will agree with some, but not all of the comments that it receives from OIRA and the other reviewing agencies. Through discussion and deliberation with interagency reviewers, the rulemaking agency ultimately produces a proposed or final regulation to be published in the Federal Register. OIRA works to ensure that the costs of new regulations that come to the office for review are justified by the benefits. To date, the net benefits of regulations issued through the 6th fiscal year of the Obama administration are about $215 billion. The benefits of these rules are not mere abstractions. They help American families every day by saving lives, preventing illness and injury, and protecting consumers. As this administration comes to a close, we intend to maintain the strong regulatory review standards that have guided OIRA's review of regulations throughout the administration. In December of 2015, I issued a memorandum to deputy secretaries outlining these expectations. The memo asked agencies to adhere to dates established in their fall 2015 regulatory plan and agenda, and to update OIRA about any necessary changes. The memo acknowledged that agencies will issue many needed regulations through 2016, but requested that agencies strive to complete their highest priority rulemakings by this summer, because OIRA needs sufficient time to thoroughly review all regulations for compliance with applicable statutes, governing executive orders, and OMB circulars. When I became OIRA administrator in 2013, one of my goals was to increase the predictability of the regulatory review process by improving the timeliness and transparency of OIRA's key functions. Toward that end, and as I committed to do the first time I appeared before this committee, we have published the regulatory plan and agenda each fall and spring, most recently on November 16, 2015, and May 18, 2016. OIRA is committed to putting out another regulatory plan and agenda in timely fashion this fall. OIRA has also worked to improve the transparency of regulatory review. When an agency submits a rule to OIRA for review, the submission appears publicly the next day on OIRA's website. This posting provides stakeholders with notice that OIRA is initiating review of a regulation and is available to meet with any party interested in providing input on a rule under review. The entities with which OIRA typically meets include members of Congress and their staffs, state and local governments, businesses, trade associations, unions, and advocates from a variety of organizations. OIRA posts a log of all such meetings on its website, detailing the participants in each meeting, the organizational affiliation of the participant, and posts any materials prior to OIRA at the meeting. One hallmark of this administration's regulatory policy is our retrospective review effort. Retrospective review, which the President has advanced through Executive Order 13563 and 13610, is a crucial way to ensure that our regulatory system remains modern and streamlined and does not impose unnecessary burdens on the American public. The essential idea is to scrutinize existing rules and assess whether in practice they are achieving their objectives without imposing unnecessary costs. Agencies released their most recent reports on March 4th, 2016, and will submit their next reports to OIRA this month. To date, this administration's retrospective review efforts are expected to yield an estimated net 5-year savings of $28 billion. In conclusion, regulations can and do bring great benefits to Americans, but they also carry costs. OIRA works every day to achieve the goals outlined in Executive Order 13563 to protect public health, welfare, safety, and our environment, while promoting economic growth, innovation, competitiveness, and job creation. It is critical to ensure that federal agencies base their regulatory actions on high-quality evidence and sound analysis. It is also crucial that a culture of retrospective review is sustained at the agencies, as any healthy organization should scrutinize its current approaches to see if they are still relevant and effective in a rapidly evolving economy. We look forward to continuing our efforts to meet these challenges. Thank you for your time and attention. I would be happy to answer any questions.
Thank you. Now we will begin the 5 minutes of questioning from each of the members, and we will try to do just as well as you did to do it within around 5 minutes. First thing I would like to bring to your attention and ask your response to, sir, is the subcommittee, which I've chaired for the last couple of years now, asked in writing for a list of all proposed or final rules reviewed by OMB since January of 2009, where the cost-benefit analysis by one or more methods of calculation would be negative if co-benefits were excluded. OIRA offered a generic reply that co-benefits are discussed in an annual report. Would you be so kind as to commit to providing the list that I just asked for by July 20th of this month?
Thank you, Mr. Chairman. I would like to take that request back and to see what it would take for us to compile that list, and we will get back to your office as quickly as possible with when we can reply.
Do you think you'll be able to get back to us as to when you can complete that list before July 20th?
Yes, I will get back to you before July 20th with an answer as to what kind of work I think will be involved with that and when we can do that.
Thank you. Your written testimony outlines steps you took, and I quote, to avoid an end-of-the-year rush, which we have seen concerning regulations with all administrations. Essentially, you requested that agencies act promptly. Supposing they refuse your request, what consequences would they face? Not could they face, but would they face with you if that information is not put together?
The memorandum that I issued in December makes clear that we at OIRA need time to make sure that we have done a thorough review, and we will uphold the standards of the executive order. The consequence that agencies will face if they come to us too late with rules is that we may not have time to do that kind of thorough review, in which case their rule would not be completed by the end of the administration.
Let's expand a little bit on that question in your statement. You said you may not have time because of what the agency has not done or fulfilled a request. But as the administrator, how do you respond to that? It's like, I ask my kids to have something done and it's not done, there are consequences. Maybe we should start running the government a little more like we parents supervise our children.
It's hard to know in advance of any rule being submitted what kind of shape the rule is in or what the review time will be. Some rules can be reviewed thoroughly and completely in a relatively short period of time. Others will take a lot more back and forth, will implicate a lot more of the equities of other agencies. So it's hard to know in advance what the consequence of a particular late submission will be. But so the operative principle that we're using is to tell them that if you submit us a rule late and it's a rule that will take more time to do a good job on, it won't be able to be concluded on. I can't tell in advance before I see a rule how long it will take to review or what the process will be. But they're on notice that we can't shortcut our process and we can't rush rules through at the end.
Don't you think there should be some type of, I don't want to use the word sanction, but some type of notice or warning, public notice or warning to that agency, to that department, that we requested this information, the time has lapsed, we've had no response. There wasn't even a situation where you've requested an extension. I mean, the American people have to understand what is not taking place, and elected officials and those that are appointed to office can simply just not ignore, because this is what gets us into the problems that we're in with the debt and a whole litany of other issues. But there are responsibilities. I came from industry. You're an officer of the court. When a judge says, I want this done by this date, if it's not done, there are sanctions. So why are the bureaucrats, why would the elected officials be immune from this? I think part of your responsibility and other administrators' responsibility is to make it publicly known that your request wasn't fulfilled and the agency is lacking in getting the American people information. What say you?
If an agency chooses not to send a rule to OIRA, that's something that's very much in their discretion. If it's not a rule that has a court order or a statutory deadline, I don't have any authority to issue a sanction because an agency doesn't send a rule over. But what I can do, and the authority that I do have, is to make sure that my office operates in a way that it lives up to its authorizing executive orders. And so what I can tell agencies, and again, it's not my, I can tell agencies, look, you're working on this rule and you say you want it done, we're running out of time. And that's the kind of thing that I can tell them. And then they have to make a decision and be answerable to the public about whether or not they're going to continue with that particular rulemaking.
I agree with you. So I'm way over my time, and I apologize, but what would help is probably you give him a little nudge and saying, if this isn't done by a certain time, I'm going to send notice over to the committee that's responsible for oversight or budgeting you, and explain to them that you're not cooperating. Maybe that's what we need. But with that, my time has expired. I thank you, and I now yield to the ranking member of the subcommittee, Mr. Johnson, for his questioning.
Thank you, Mr. Shalansky. I have serious concerns that the cost-benefit analysis requirement for significant rules comes at the expense of Americans' public health, safety, and environment. How can we possibly quantify the benefits clean drinking water will have on a neighborhood when new solid waste regulations protect that neighborhood from coal ash dumping? How can we possibly quantify the benefits that clean drinking water would have based on a newly promulgated rule that protects that neighborhood from coal ash dumping? How can we accurately quantify the cost of exposure to dangerous chemicals and toxic materials on the long-term development of children in low-income and minority communities? Repeatedly, critical public health rules are called too burdensome for corporations to comply with. But what about the communities at stake? Communities who find the cost to their health, safety, and well-being not factored in because it does not have an easily quantifiable dollar figure. What about the burdens that those folks face? Regulation should act as a floor, not a ceiling. Rather than weakening rules to lower the cost they have on big business, we should be strengthening rules so the burden on the American public is not too costly. In light of these concerns, should we reform OIRA's review process so that it is more reflective of the cost and benefits that rules have on the health and well-being of everyday people?
Thank you very much, Mr. Johnson. It's a very important question. I do think it's very important to quantify as much as possible the costs and benefits of a regulation. I think it's important for the American public to understand what regulation is costing them. I think it's extremely important for the business stakeholders to have notice of what their compliance costs might be. It is important that our regulation remain consistent with economic growth and job creation. On the other hand, we well recognize, and indeed our executive orders well recognize, that there can be limits in our ability to quantify benefits. So there is not a rigid requirement that quantified benefits exceed quantified costs, because there is a recognition that in some place there are benefits that can be proven to exist, but as you say, are hard to put a dollar figure on. So what we ask agencies to do is to quantify as much as available scientific evidence and health evidence will permit what the reduced illness incidence will be, what the reduced death and injury incidence will be of a rule, and to quantify those by some very well-established techniques. But we also recognize that in some cases the evidence will be difficult to come by, and there we look for a strong case that the rule will achieve its intended goal of, for example, clean drinking water or cleaner air, and that there is good evidence that those changes will be reflected in public health gains. So I would not be in favor of reforming the executive orders and the cost justification principles that underlie them. I think they're very healthy, and I think that they are consistent with providing the kinds of benefits that you articulated, sir.
Thank you. Anti-regulatory measures such as H.R. 185, the Regulatory Accountability Act, and H.R. 4768, the Separation of Powers Restoration Act, have been proposed to heighten judicial review of agency rulemaking. You previously testified that you have grave concerns with conducting judicial review at a granular level because it could grind to a halt the deliberative process and good policy development. What are some examples of rulemakings that would be particularly sensitive to heightened review?
Thank you, sir. My concern about judicial review is of the kind that has been suggested in some proposed legislation, is that it would put judges in the position of reviewing very detailed kinds of factual decisions that expert agencies typically make, and would really overturned decades of precedent about the appropriate scope of deference to fact-finding and decision-making in the agencies. And the result would be that it would be very hard to move forward in rulemaking if at every given stage, every determination of the agency could be second-guessed, no matter how material judicial review. So I do have some concerns about judicial review of OIRA determinations or a very of agency determinations for the reasons that you set forth.
Are you concerned that heightened judicial review may empower courts to make substantive determinations?
Yes, sir, that is one of the concerns. I think that the system of judicial review that is in place over decades of Supreme Court precedent is designed to have courts take one step back from those kinds of very detailed, substantive determinations, and my concern would be that agencies would find it very difficult to make progress on necessary regulations that respond to pressing public needs if they would face that kind of judicial review.
Thank you, sir, and I yield back.
Chair recognizes the gentleman from Texas, Congressman Radcliffe.
Thank you, Mr. Chairman. Sorry, I was deep in thought there. Mr. Chairman, I appreciate you holding this hearing, and I will tell you that I think the work this subcommittee does is some of the most important work that we do here in Congress. I can tell you from the constituents that I have in Texas, the issues that we're talking about here, including what the gentleman from Georgia just referenced, are very personal to my constituents. I'm afraid that sometimes here in the halls of Congress, the statistics and the numbers and the clinical terms that we use in these hearings desensitize all of us to the real impact that policy decisions have, whereas I can tell you the folks back in Northeast Texas aren't. They see these issues in very clear terms like jobs and the uncertainty of their jobs and the stagnancy of their wages with respect to jobs and not getting pay raises for decades, how it impacts their families and their futures. And from the conversations I've had with constituents, it's painfully clear to me that so many of the burdensome regulations are inflicting real harm on individuals and families. And making matters worse at times is the attitude of indifference at best and condescension at worst from federal regulators. Sometimes when I ask about the consultation process and whether or not there has been any meaningful consultation with stakeholders in a respective area or industry, the response is too often laughter. I think that this concept at times isn't taken seriously by some of the regulators. And the regulations, listen, I'm not against regulations. They certainly serve a purpose when they're done correctly. They can enhance consumer safety, they can promote responsible stewardship of resources, and they can improve the lives of everyday Americans. But when regulations go wrong, which is what we see so often today, they can be impossible to comply with and impossible to rectify or to reconcile with plain old common sense. And so I think a great example of that is what some of the unelected bureaucrats are doing at some agencies, impacting millions of Americans with misguided, misinformed approach to the regulatory process. Let's take the internet. Everyday Americans use the internet for communication, for commerce, for internet, for the daily operations of their lives. And I think that any regulation that is so far-reaching should be done with extreme caution and undergo an intensive review process. Unfortunately, that's not what's happening. So last year, the FCC voted 3-2 along party lines to approve the Commission's net neutrality rule, or as my A friend from Texas in the Senate calls it Obamacare for the internet. But let's for a second set the policy debate about this new rule aside and talk just about the process. And the FCC is using the Communications Act of 1934 to justify its regulation of the internet. And bureaucrats at the FCC had said that it was the intention of this body, of Congress, to see that broadband internet service was regulated like a telephone utility back in 1934. Now, I can't remember the exact year that Al Gore invented the internet, but I'm pretty sure it was after 1934. And I think it underscores the issue that we're talking about here. And, with all due respect to the gentleman from Georgia and his comments about some of the legislation, admittedly, some of that legislation, the Separation of Powers Restoration Act, is my legislation, and it's aimed at exactly this problem. And your response, Mr. Schlansky, about judges not having the expertise that some of these agencies have to make these decisions, I would point you to the one that I just said to highlight the fact that unelected bureaucrats at agencies are not always experts on issues. And to correct another point, my legislation does not go to factual findings. It goes to legal interpretations, which is what judges are trained, vetted, and ultimately confirmed to do. So let me ask you on this, while we're on the topic of the FCC, is because it's an independent agency, this enormously consequential rule is exempt from the cost-benefit framework and OIRA review. And as a result, OIRA is not able to promote adherence to the review measures, which are designed to ensure, I think, that rules that govern the lives of the American people have undergone a thorough cost-benefit analysis and determined to be the least burdensome alternative. As you probably know, in 2012, the President's Council on Jobs and Competitiveness recommended that independent agencies like the FCC be required to perform cost-benefit analysis and subject their regulations to OIRA review. I know that you previously worked at the FCC, correct? Do you, first of all, agree with the recommendations made by the President's Council? And if so, how would this, in your opinion, change the benefit or the quality of independent agencies' rulemaking?
Thank you very much, Mr. Ratcliffe. This touches on a very important issue. President Obama, in some of the executive orders that he has issued that govern OIRA, has actually very strongly encouraged the independent agencies to use some of the rigorous cost-benefit analysis that that executive branch agencies are subject to during OIRA review. I do have some concerns, separation of power concerns and other concerns about subjecting independent agency rulemaking formally to OIRA scrutiny. I do agree, however, that the principles of cost-benefit analysis are ones that are good for any agency, whether it's executive branch or independent, and that encouragement of those agencies to use those kinds of mechanisms would benefit the quality of their rulemaking and the American public.
Thank you. I see my time's expired.
Thank you.
Back.
Chair now recognizes the gentleman from Michigan, Congressman Trott.
Thank you, Chairman, and also Ranking Member for organizing this hearing. And Mr. Schlansky, thank you for appearing today and for your work on behalf of our country. You have a very impressive background, so no question, a PhD in economics from Berkeley and clerking for Scalia and of counsel at Davis Polk and many great accomplishments. Have you ever run a business, though?
I have not run my own business, sir.
Spent 2 years in private practice, right?
That's correct, sir.
So never signed a paycheck, never managed to a bottom line or a budget.
Just the household, sir.
Okay. So I took a family business with 6 people, grew it into companies with about 2,000 people. We couldn't have done it today. couldn't have done it, and even if we could have done it and made a profit, wouldn't have wanted, or heavily regulated businesses, wouldn't have wanted to take the risk. So let me share with you, at a high level, do you think that, you cited in your opening statement that over the last 6 years, all the benefits to the economy with the President Obama's regulatory efforts, and do you think, with respect to small businesses in our country today, over the past 6 years, that the regulatory environment is supportive, or is it too onerous, or just about right? Kind of the Goldilocks question for you.
Thank you. I think that's a hard question. I will say this. Small businesses face unique challenges, and we have a system of regulatory review that is set up to try to take specific note of those, and we do work closely with the Office of Small Business Advocacy to try to understand the specific effects that will occur on small businesses. So we certainly work to try to make it just about right.
Well, so that's a good segue. So last week in the district, I met with some independent party store and gas station owners. And I was impressed with their knowledge. I thought only people in Washington understood all of our acronyms, but they had all the acronyms down. And during the course of the meeting, they said to me, we cannot continue, would never open another party store or gas station in today's environment. These are independent business owners in my district because of the following acronyms: EPA, FDA, ACA, and of course the Department of Labor and some of their rules and regulations coming at them. So when I go home, I hear 3 questions. Why can't you get anything done in Congress? Why can't you stop President Obama? So I'm not going to ask you to opine on the first 2 questions. But if you give me some insight into the third question I get asked, which is, can't you get Washington out of the way? I can't run my business in today's environment. What should I say to those folks about the future of small business in America and free enterprise, which I believe is the reason why we're the greatest country in the world?
I think that the problem you allude to is the problem of cumulative burdens of regulations.
No doubt.
That each regulation in itself may have a justification and may look fine, but by the time you're a business starting up and you've got multiple regulations that you need to address, it becomes a very difficult enterprise. And I think that to deny that this is a critically important challenge for regulatory review and for agency rulemaking would not be candid. We do strive at OIRA, when we meet with stakeholders and when we work with agencies, to try to get agencies to look more broadly outside of their rule, to understand what this rule does to add to the effects on profit margins in a particular sector. So it is within our mandate, and it is something that we've worked very hard to do. The best answer I can give you is this is an area in which we continue to work with agencies, and I will agree with you that more attention needs to be paid to how we can account for cumulative burdens.
Okay, so let's talk about major impact and rules that have major impact, which is the focus of your office. And in connection with that, let's talk about the REINS Act. You're familiar with the REINS Act? So tell me why that's a bad idea.
The administration has issued its view on the REINS Act, and I think that what underlies that view is a concern that Congress has the authority already to disapprove any major regulation under the Congressional Review Act.
That hasn't gone so well because half of the president's vetoes have been of resolutions that we pass under the CRA, right?
Yep. So but one of the concerns is under the REINS Act, an agency would issue a major rule, right, and then there would have to be a majority of Congress to ratify that rule. And I think my concern is that this could really make it very difficult for important major rules to get done, because they could be done very well, they could meet a very specific need, and then still not marshal the necessary majority.
But you would concede if we had the REINS Act in place, it would give me a better answer when I go home and I have to explain to small businesses why we haven't been able, the elected representatives of the people, haven't been able to weigh in on regulations that have an impact of over $100 million on our economy. I mean, that's a disconnect for me, because all I can point to is the fourth branch of government, the growing bureaucracy, which is, again, one of the questions I get hit with a lot. Why has Washington gotten so big? And then the other, and I run out of time, but the other question I get when people come visit here, tourists, and see our Capitol and the White House, is they comment on all the cranes that are in Washington. They've never seen so many cranes. And we all know Washington didn't have a recession like Detroit did, and we all know that Washington continues to grow because government just grows and grows beyond. But I thank you again for being here, sir, and I yield back my time.
Seeing no other members on the dais, this concludes today's first panel. Administrator, I want to thank you so very much for being here. And once again, I apologize for the delay. I want to thank you for agreeing to get that information to me before the 20th. I really appreciate that. You are excused, sir.
Thank you, sir.
And would the second panel please come up to the hearing table? Good to see you. If you need something, thank you.
Thank you, sir. Good job.
We have 3 Republicans, 1 Democrat. We're missing Wayne Cruz. I don't know where he is.
Okay.
That's weird. Where'd Wayne Cruz? What's that? He was here?
We're going to get started. Okay. We are missing one of the witnesses, but we're going to get started in the interest of time. I would ask the gentleman at the table, would you please stand and raise your right hand to be sworn in? Do you swear that the testimony you're about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated and let the record reflect that the witnesses have acknowledged in the affirmative. Mr. Cruz, if you would just continue standing and raise your right hand, would you please? We just swore the other witnesses in. Do you swear that the testimony you're about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the witness has acknowledged that he does affirm in the positive. We have 4 distinguished members of this area of expertise to testify before us today, and I'll begin with introducing Dr. William Beach. Okay. William Beach is the Vice President for Policy Research at the Mercatus Center at George Mason University. Dr. Beach previously served as the Chief Economist for the Senate Budget Committee Republican staff. Prior to that position, he was the Lazoff Family Fellow in Economics at the Heritage Foundation and Director of the Center for Data Analysis. Prior to joining Heritage in 1995, Dr. Beach served as a senior economist in the corporate headquarters of Sprint United Incorporated, and from 1991 to 1995 as the president of the Institute for Humane Studies at George Mason University. Dr. Beach received his bachelor's degree from the Washburn University in Topeka, Kansas, his master's degree in history and economics from the University of Missouri-Columbia, and a PhD in economics from Buckingham University in Great Britain. Welcome, Doctor.
Thank you very much. Chairman Marino, Ranking Member
Sir,
Johnson.
I'm going to just go through everybody's, give you a little.
That held against my time.
No, we'll start from ground zero. Our next invitee is Mr. Clyde Wayne Cruz, Jr. Mr. Wayne Cruz is Vice President for Policy and Director of Technology Studies at the Competitive Enterprise Institute, a former Cato Institute scholar, as well as a Senate and FDA staffer. He is widely published and a frequent speaker on a range of policy issues at venues including the National Academies, European Commission-sponsored conferences, and the Spanish Ministry of Justice. Mr. Cruz is co-editor of the books Who Rules the Net? Internet Governance and Jurisdiction, and Copy Fights, The Future of Intellectual Property in the Information Age. His other works are cited in dozens of law reviews and journals. Mr. Cruz is a father of 5, received his BS from Lander College and his MBA from William and Mary. Welcome, sir. This is the next witness is Professor David M. Dreesen. Is that correct? Dreesen. Thank you, sir. David M. Dreesen is a university professor at Syracuse University, the 13th person in the history of the university to receive this honor, and a member scholar of the Center for Progressive Reform. He teaches environmental law, and his scholarship focuses primarily on law and economics and environmental law, including a substantial body of work on OIRA, or otherwise known as OIRA, review and cost-benefit analysis. His books include The Economic Dynamics of Environmental Law and Economic Thought in U.S. Climate Change Policy. He sits on the editorial board of various international environmental law journals. Professor Dreesen holds a bachelor's degree in music from Oberlin College, a master's degree in music from the Yale School of Music, and earned his his JD at the Yale Law School. Welcome, Professor. Our final witness is Dr. Holtz Eakin, built in an international reputation as a scholar doing research in areas of applied economics policy, econometrics methods, and entrepreneurship. He began his career at Columbia University in 1985 and moved to Syracuse University from 1990 to 2001. During 2001 to 2002, he was the chief economist of the President's Council of Economic Advisors. From 2003 to 5, he was the 6th director of the Nonpartisan Congressional Budget Office, which provides budgetary and policy analysis to the U.S. Congress. Currently, he is the president of the American Action Forum and recently was a commissioner on the congressionally chartered Financial Crisis Inquiry Commission. Dr. Holtz-Eakin received his BA from Denison University and his PhD from Princeton University. Welcome, Doctor. Thank you all for being here. Now, Dr. Beach, you're up.
Thank you very much. Chairman Marino, Ranking Member Johnson, Congressman Trout. It is really a great pleasure to be here with you today. I'm going to testify about OIRA and cumulative cost and what we can do in terms of asserting Congress's authority in these areas, particularly in the regulatory budget. But I'd like to start with just a statement about the economy. The economic world changes most and for the good in economies where rivalrous economic behavior is allowed most to flourish, that is, in economies devoted to free enterprise. Congress has no end of the number of things it has to do. I should know, I was once working not so long ago in the Senate, but near the top of the list of to-dos is the protection of this amazing process of value creation through innovation, discovery, and competition. We depend utterly on the private sector to produce nearly all of the material things we value, while the public sector is necessary as a partner in the production of these by providing public goods, courts, highways, and so forth and so on. You wouldn't want it any other way. The betterment of the American people since 1900 is almost wholly the accomplishment of competition between entrepreneurs trying to obtain the consumer's attention for their products and services. Given the vital place of the competitive economic world in bettering the general public, Congress must be especially vigilant of the regulatory burden it imposes on the economy. In this vein, I am particularly eager to draw the committee's attention to 3 areas of regulatory policy where I have some concerns. 1, the decay of regulatory impact analysis. 2, the economic effects of regulation, the cumulative costs of regulation. And 3, the growing absence of Congress in directing the future developments of the administrative state. And let me briefly mention all of these in turn. On the regulatory impact analysis, policymakers in Congress would largely be in the dark, Mr. Chairman, about the expected effects of regulatory policy changes were it not for the development of regulatory impact analysis, cost-benefit analysis, it's also called. The administration's oversight of RIAs is lodged, as we heard, in OIRA. Under normal circumstances, this small office would have trouble enough monitoring the adequacy of these many rules. But I'd like to point out to you that it has
some difficulty doing it because its staffing has been halved. It started off in 1981 with 90 people. It now has exactly 50% of that at 45. So one of the things we can do to stop the hollowing out of our our cost-benefit analysis is to adequately staff OIRA. So what should we do to improve the quality of regulatory impact analysis, cost-benefit analysis? You asked that, Congressman Johnson, in your opening remarks. First, improve OIRA's resources. Without adequate staffing and other resources, the office's capacity to improve RIA quality, cost-benefit analysis will be substantially compromised. Two, implement the process reform described in the recently passed House bill, the Administrative Procedures Act, that requires agencies to produce preliminary regulatory impact analysis and submit that to public comment before sending in its final RIA cost-benefit analysis to OIRA. Our research indicates that preliminary analysis with public comment yields much better final results. And three, Congress should require all agencies to perform cost-benefit analysis when proposing major regulations. Let me go to my second point, the increasing effect of regulations on the economy. I'm with everyone who has so far spoken today in being a fan of regulations. You can look at one regulation in one area, one regulation in another, and always make a good case. But there is a mounting likelihood that the cumulative effect of regulation is slowing the economy. We've just finished some research in this area. How much declining growth have we experienced because of the cumulative rapid rise of regulation? My colleague Patrick McLaughlin, who couldn't be here today, and his co-authors recently used a growth model of the U.S. economy in a peer-reviewed piece of research and data from the Code of Federal Regulations to estimate that there's a $4 trillion loss in GDP in the base year of 2012. Now, what does that mean? That is, had regulations remained the same as they were in the heavily regulated year of 1980, the economy in 2012 would be $4 trillion higher than it actually was. Now, that's a decrease of 25% from what it potentially could have had. There were 135 million employees working in 2012. That means, if you do the math, 25% more employees, we're missing 34 million jobs. Finally, I'd like to say a quick word about regulatory budgeting. At issue in my two previous points, the importance of RIA work and the mounting case for regulations are on net harmful to economic growth, is the need for congressional policymakers to attend to more regulations than they have in the past. So what I'm advocating here is that Congress be a little more assertive in terms of what it does to authorize the spending of agencies that are pushing more regulations on us. And a regulatory budget is an idea whose time maybe has come. It was first proposed by Lloyd Benson, and there are a number of members who are very interested in regulatory budgeting as a way to contain and control the growth of regulations. There's a good deal more in my written testimony, which has been submitted for the record. Thank you very much.
And let me remind everyone, and thank you for the reasonable time. There are timing lights in front of you. I think those of you who testified here before, if there's someone here that hasn't, I'm just going to say you have 3 lights. By the time that gets to the last red light, that means your time is up. The light before that gives you 1 minute, and please try to stay within that period of time. And if you need to express anything, we can give you some time during the question and answer session. So, Mr. Cruz.
Thank you. I'm Wayne Cruz, Vice President for Policy at the Competitive Enterprise Institute, a libertarian policy and advocacy group, and I thank the committee for the invitation to address regulatory oversight. $19 trillion federal debt notwithstanding, when policymakers neglect regulation, they ignore arguably government's greatest influence in the economy. Both spending and regulation reorient societal resources and priorities. Yet members may have noticed there's still no sign of the 2016 OIRA report to Congress, so what reviewed regulatory cost figures we have are nearly 2 years old. Last year's report was the latest ever. Congress confessed to overdelegation last month in last month's Article 1 Task Force report, so code law is here to stay for the moment. OIRA should help lawmakers create a regulatory transparency supernova to spur economic liberalization. I was struck by a businessman writing in the Financial Times. He said, "When I am 100% utterly and completely certain that it is an absolute certainty that it is an absolute necessity that I need to recruit a new employee, I go to bed, sleep well, and hope the feeling is past by morning. While those doing the regulating see no problems, exasperation is rampant. Home Depot co-founder Bernie Marcus said the company couldn't succeed if started today. Other polls say businessmen wouldn't do it again, and startup rates and part-time employment rates affirm this. Employment, like poverty, doesn't have causes. Both are the default state of mankind. Only wealth and production have causes, and regulatory zeal can derail enterprise. Problem is, legislatures rarely control spending, let alone the regulatory enterprise, and OIRA's central review machinery can't overcome presidents who deprioritize oversight or a regulatory system that frontally benefits rent-seeking special interests. Over 3,000 rules are finalized annually, but only 13 rules in the 2015 OIRA report reviewed cost and benefits. The proportion of all rules with OIRA-reviewed cost-benefit analysis is less than 1%. On the rest, we don't have cost-benefit analysis, we have agency selfies. The 800-pound gorilla independent agencies get no OIRA scrutiny, nor do the thousands of guidance documents and memoranda that I've taken to calling regulatory dark matter. Such chasms weaken the OIRA report's authority as a comprehensive survey of regulatory impact, especially since unmeasured categories of regulation propel cost as well, such as antitrust, the locking up of Western lands, or the reluctance since the 1890s to move spectrum and other commons into market disciplines. When government steers cross-sectorally as it does today, it creates mounting costs even if no future rules are issued, such as Congress's delivery of the internet and, as of 2 weeks ago, drones into century-old public utility models. Also new is EPA's central planning of electric charging and hydrogen fueling stations in the wake of the Volkswagen settlement. Alas, much is beyond OIRA's scope. Businessmen want to create jobs, but everything has limits. Jobs are a cost, they're a liability, and policymakers should recognize that. While a Vanguard study blamed hundreds of billions in cost on regulatory uncertainty, it said that sometimes the certainty of regulation is worse. My optimism stems from knowing there'll always be an America, even if it's not here. But I do not believe members wish to go to the mat maintaining regulatory overreach, and I hope members will jointly think through some North Star goals to enhance OIRA. Ronald Reagan's Executive Order 12291 that energized OIRA in the first place showed the so-called pen and phone can also expand liberty by reducing Federal Register page counts and numbers of rules. Members can work with OIRA to enforce and codify the regulatory review executive orders, address independent agency cost, and illuminate regulatory dark matter. Other steps noted in my written testimony include boosting OIRA resources and free market law and economics staff at agencies, pausing regulation, and implementing the Bipartisan Regulatory Improvement Commission. I highlight also the former regulatory program of the U.S. government, a model by which OIRA could compile an annual regulatory transparency report to parallel the historical tables in the federal budget, optimally reporting separately on economic, health and safety, paperwork, and environmental and other costs. So while central review hasn't worked, just possibly it could, when it comes to economic expansion, you don't have to tell the grass to grow, but you do have to take the big rocks off of it. So why not use OIRA as a lever? Thank you very much.
Thank you. Professor Dreesen?
Chairman Marino, Ranking Member Johnson, members of the committee, thank you for inviting me to testify. I think a key question we need to ask is whether OIRA helps us confront the major challenges that government standards address, such as global terrorism and climate disruption. I'm going to suggest today that OIRA has not helped us confront those challenges and propose some reforms that would make the process more efficient. OIRA has not helped us confront these and other key challenges because it always delays standards, usually needlessly, while doing nothing, and never speeds them up. And because when it does recommend changes, in almost every case, the changes proposed weaken the standards. Now, government agencies already face substantial pressures to inadequately protect public health, the environment, and our safety, because regulated companies file voluminous comments, meet with agency officials, get concessions from them, sue them anyway, and then the courts will make them do this all over again if they did not respond adequately to any of these comments. And these are very well-funded interests, and we don't need yet further gauntlets to interfere with these vital protections. The primary justification for OIRA review, as I think you heard today, is the idea that an Office of Economist should help government agencies use cost-benefit analysis to improve the most expensive standards. OIRA, however, focuses mostly on standards where no cost-benefit analysis can be completed because none of the benefits are quantifiable. And it overwhelmingly focuses on rules that are not economically significant, that generate costs less than the $100 million threshold in the law. So I have the following recommendations to streamline the process and make it much more efficient. First, OIRA should be permitted only to review standards that generate costs of $100 million or more. This would force the agency to prioritize and allow its small staff to review rules in a timely manner. Second, we should exempt rules that address terrorism and global climate disruption from the review process. These are cases where cost-benefit analysis cannot be helpful because it is radically incomplete on the benefit side in both of these cases. And these are areas where it cannot afford the delays that are routine in the OIRA process because there are risks of catastrophes and we don't know when they might occur. So in these cases, there should be no OIRA review. We also should demand that OIRA not review agency risk assessments. This is an Office of Economists. Risk assessment requires scientific expertise that the agencies possess, but OIRA does not. And risk assessment, by the way, is the way that we come up with the number of lives saved, the number of illnesses avoided, and so on. Monetization economists know about that, but risk assessment, they don't. Fourth, when a cost-benefit analysis shows that the monetized benefits exceed the monetized cost, OIRA should be pushing for stricter standards because those maximize net benefits. They do not follow economic theory in this respect, never have, except on one occasion I can think of. The other thing we need to do is instruct the agencies to ignore OIRA's input if the review process lasts more than 90 days. The current executive order has sought to limit the time of review. OIRA has evaded these limits. So we need a simple rule and we need an enforcement mechanism. So my conclusion is that OIRA review has not helped us address key challenges that government standards address, including climate disruption and global terrorism, and that we need a much more efficient, streamlined processes so that OIRA's resources will be used properly and not produce inordinate delays. Thank you very much for your attention, and I welcome your questions.
Thank you. Dr. Holtz-Eakin.
Thank you, Chairman Moreno, Ranking Member Johnson, Congressman Trott, for the privilege of being here today. You have my written statement. Let me make 3 brief points. Point number 1 is there has been a clear explosion of regulatory burdens in the Obama administration. OIRA reports that it has issued 453 economically significant regulations. That's 38% more than the Bush administration. That's 41% more than the Clinton administration. It's above historic norms by a large margin. At the American Action Forum, my colleague Sam Batkins and his staff do a comprehensive review of regulatory issuance. They read every single final regulation and the agency's self-reported compliance costs. Over the 7.5 years of the Obama administration, the total is $800 billion in new regulatory burdens. That's about $250 for every every person in the United States. And given the concerns that have been expressed by the chairman and others about the pace of midnight rulemaking, that total is certainly going to go up perhaps dramatically. The second point is that these burdens do not disappear. They have economic consequences. The regulatory burden has to show up in the form of higher consumer prices, or it has to show up in the form of lower wages and employment, or reduced profits and the ability of firms to survive, or even desirability to enter. American Action Forum looked at 36 major regulations, as I indicated in my testimony, and found that they raised consumer prices by a cumulative $11,000. These are significant impacts on prices. This isn't AAF alone thinking this. When the Department of Labor issued a silica rule that had a $9 billion cost, it pointed out that for some of the smaller firms, those costs would represent 90% of their profits, but that was not to worry. That would simply be passed on to consumers. If it doesn't go to consumers, it's got to go somewhere else. So in work, we looked at the impact of the 2008 ozone rule, and if you look at non-attainment counties compared to those in attainment, the impact is about $56.5 billion in wages, or about $700 per worker, and a loss of something like 240,000 jobs. So you're going to see these burdens in prices or wages and employment, or just in general economic growth. I mean, if you look at $800 billion, that's $100 billion a year and 60 million paperwork hours a year. You have to believe that if we had a $100 billion tax increase every year, everyone in America would know it. It wouldn't be a hidden cost. And a lot of people would be saying, gee, I'm not so sure that's a good idea. This has been a terrible recovery by historical standards. And I think it is no coincidence that for the past 3 years, for the first time, the rate of birth of new firms in the U.S. economy has dropped below the rate at which firms fail. We are not seeing the traditional American entrepreneurism show up in the data, and the regulatory burden, I think, is contributing to that. Final point is that the retrospective review process is not taking away existing regulations, so this is just new layers of burden on top of the old. The President signed, as has been mentioned, Executive Orders 13563 and 13610. If you look at our analysis of the impact of those EOs, that raised the cost of the regulatory state by $16 billion. It went the wrong direction from a retrospective review point of view. And one of the reasons is new regulations, things like the gainful employment rule or new greenhouse gas controls, are being classified as retrospective when in fact they're new regulations. And all of this suggests that the EO process, not just with President Obama, but with previous presidents, is not a powerful enough tool for retrospective review, and that Congress should think about an alternative mechanism, whether it be the Scrub Act or other legislation that I know the committee has considered. I thank you for the chance to be here today, and I look forward to your questions.
Thank you. I will start by questioning the witnesses for my 5-minute period. Dr. Holtz-Eakin, what are some potential reforms that could stem midnight regulations?
There are a range, and I think the question is which ones would be the most desirable. So, sometimes people want to just put a freeze on regulations. I think that's too blunt an instrument. I'd prefer to have changes to the regulatory process that would sort of make the midnight rush impossible. So, for example, there is the Alert Act that the House has looked at. That kind of transparency, knowing what's coming down the line, the timetables for rulemaking would in fact stymie the midnight activities. And so I think look to the entire regulatory process, reform that, and stop the midnight rush in the process.
Dr. Beach, when the administration, whatever the administration it happens to be at the end of their period, imposes major changes through guidance or other regulatory dark matter, is there damage to the economy, and is there damage to our government and our liberties?
Well, yes, I happen to believe that. I think that when you have an accumulation of regulations, whether it be in the major rules, it be in the minor rules, or it be in the dark matter that Wayne has so eloquently developed, these add to the costs of investment, they add to the costs of labor, they add to all those costs which go into the operation of a business. One of the reasons, as Doug pointed out, we have such a low level, and a stunningly low level of firm creation has to be in the barriers which we've set up on the cost side, with all good intentions of helping people protect themselves against health and other kinds of injuries. It has prevented a lot of entrepreneurship. I'm very concerned about that.
Mr. Cruz, to get to respond to my
The
question.
same. Yeah, well, it's one of the things that you look at what OIRA's purview is. There are 3,400 or so rules that go through every year, and OIRA looks at about 500 of them. There are about 60 that it looks at, including budget rules, where there are just transfers involved. But then it's just a very small handful that get any cost analysis at all. But on top of that, as the economy gets more complex, I think there is a concern now. There was a hearing in the Senate last week on this of of agency guidances and memoranda and notices and bulletins. There's a whole word cloud of these things that agencies are using now to effectuate policy, and I think that matters a lot. We do have some review at OIRA. We didn't talk about it earlier when the administrator was here, but there is a good guidance practices memo from OIRA by which agencies they don't have to present their so-called economically significant guidance. By my brief inventory of it, there are 580 pieces of that, but that's equivalent to the number of major rules that go through every year. But those are scattered all over the place in terms of where you can find them on agency websites, so it's very, very difficult. We've got a very complex economy now. We've got a lot of new high technologies coming across the board. The FAA just dropped its drone rule 2 weeks ago, and I was just curious about this guidance issue, and I just glanced. It's a 500-page rule, but I glanced through it quickly, doing some word searching, and there are at least 6 substantive areas in there where the agency says, well, we're just going to issue guidance in the future. And the same thing has occurred with the Dodd-Frank law and the unfair and deceptive trade practices principles there. Not regulations in forthcoming, but the administrator saying, we're not going to issue regulations. You just need to check with us. FCC was brought up earlier. Page 88 in the 400-page Federal Communications Rule on net neutrality, it says, well, from now on, we're going to be using these administrative notices like the FTC does with respect to antitrust. So you see, we've got a complex economy now that's increasingly at risk of being regulated not by laws passed by this Congress, not even by the regulations that go through the Administrative Procedure Act, but more of this guidance. So that's why I think some of the guidance material is a great concern. OIRA does have some authority and even some ability, or it could just take the initiative to look at it and make the disclosure of it much more transparent.
Professor Dreesen, tell me if I've understood you correctly. You were saying that there's no need for OIRA at all?
No, I think we could do without OIRA, but that's not what I suggested today. What I suggested is that a focus only on these rules that cost over $100 million a year and that get out of a couple of areas that are really vital to safeguarding America from real economic calamity like we experienced when we had the deregulation causing the financial crisis, that is climate disruption and terrorism, where the cost-benefit analysis is not going to do us any good because it's too incomplete, and where the science of climate says there are tipping points out there that could set off runaway warming. We don't know where they are. And terrorism's the same way. You don't know what the next thing is going to be. And that's for that reason you can't quantify the benefits. And there's potential disasters here. So I'm suggesting this narrowing.
Dr. Holtz-Eakin, you heard the professor's comment about quantifying cost. But there are, in my opinion, many other areas where we can quantify cost, and particularly when it comes to jobs and more so small businesses. What say you about regulations that have come down with this administration beyond what we've seen in the past, but other administrations as well? What's it doing to our jobs in the United States, and particularly small business jobs?
I think it's been quite damaging. I understand the argument that says there are the benefits out there that need to be quantified as well. I want to echo what I believe Administrator Shalansky said very well, which is you should try to quantify everything you can. And that imposes a discipline on the rulemaking process that's actually very important. But it is easy to quantify the costs. We take the agencies at face value. I'm not even sure they're right, but even with those estimates, $800 billion of cumulative burden in 7.5 years is just like putting $800 billion of taxes onto America's businesses and small businesses. And the evidence on that impact on jobs, wages, growth is unmistakably bad.
My time has more than expired, and I now asked Congressman Johnson for 5 minutes of questioning, or 6.
Thank you, sir. Dr. Holtz-Eakin, do you have any evidence whatsoever that the Obama administration plans a midnight rush of regulations prior to its exit from the presidency?
We know only that in past administrations this phenomenon has happened. And
you don't see any evidence that it's going to happen in this administration.
And we have some suggestive evidence presented in the written testimony of trying to sort of get things out before May, which is likely when the Congressional Review Act hits. That's what we know.
No evidence of a midnight rush. That's kind of like a hidden kind of situation that's sprung on people at the last minute. They can't do anything about it. We don't have any evidence that that's what the Obama administration is planning.
If they're planning, they didn't call me.
Okay, well, so you have no evidence, isn't that correct?
The evidence I have, I told you about. We have a chart and we have history.
Okay, all right. Well, let me ask you this. You remember when Alan Greenspan came to testify before Congress back in 2008 about the fact that he had made a mistake in believing that banks operating would be operating in their own self-interest, and thus it would be not necessary for the government to protect their shareholders and institutions. You remember that?
I remember he testified. I don't remember the details of it.
And do you remember he did say that he made a mistake about thinking that we didn't need any regulations?
I'll take your word for that.
Well, that's what he said. I mean, you remember more than the fact that he testified before Congress. I know you remember that he did a mea culpa, and he said, look, I made a mistake. You don't remember that?
Everybody makes mistakes. I don't find that a shocking statement.
Well, the mistake that he made was he said that the government should play a much more active regulatory role over financial firms. Do you think that that was wise in the light of the Great Recession that he was talking about?
I think that it's too simple to pin the Great Recession on financial regulation. And the reason it's too simple, if I could finish, is
do you believe that it occurred due to lack of regulation or over-regulation?
There was over-regulation at Fannie and Freddie. There was under-regulation in some cases. The issuers of subprime mortgages at the state level were often very unregulated. We saw some really bad mortgage origination.
So regulation would have helped that, wouldn't it?
In some cases, better prudential regulation would have helped. In some cases, we over-regulated.
And it was the lack of regulation that enabled it to happen. That's what Greenspan was talking about, correct?
You can question him about his views. What I'm saying is my experience on the commission is that there were evidence of both over-regulation and under-regulation.
Ask one of the other hostile witnesses, if I will. Mr. Cruz, would you agree that Mr. Greenspan was correct when he said that we needed more regulation in the financial markets to prevent a reoccurrence of the Great Recession that threatened to become a Great Depression?
The financial markets have been heavily regulated for 100 years. We have a Federal Reserve. The federal government sets interest rates and money supplies. We testified, I don't know what committee it was, but in 1999, making the case that the government-sponsored entities that were extending home ownership beyond what could be handled was going to lead to problems. It's in the record. You can see that.
Well,
You asked the question about regulation.
There have been some regulations that resulted in some harm, but I'm asking you about the lack of regulation that resulted in harm.
I don't understand talk of a lack of regulation, because in free markets, there's no such thing as a lack of regulation. Laissez-faire doesn't mean companies get to run around and do whatever they want to do.
Well, that's exactly what was happening.
I just said we had a
Great
heavily
recession in the
heavily
financial
regulated
markets.
financial sector. But you have a lot of forces that are arrayed against companies that misbehave if you're not thinking that a central regulator is going to take care of the problem, and I don't think that they are.
But what, you're
Media,
talking about
Wall
free
Street,
market
consumers,
forces
a lot of them.
that would
Consumers,
govern?
media, exactly.
Well, let me ask you this, Mr. Cruz, since I'm talking to you. The Washington Post awarded the famous 2 Pinocchios to claims based on your report on regulatory costs. 10,000 Commandments was the name of it. They called it misleading, unbalanced, and idiosyncratic guesstimate with serious methodological problems. What is your response to their characterization of your 10,000 Commandments paper, which they gave a 2 Pinocchios?
Well, maybe that they should have read the subtitle. This was the Washington Post. The paper that they're referencing was called Tip of the Costberg. It's a working paper compiling OMB numbers on the cost of regulations on environment, health and safety, and OMB has quit compiling the paperwork costs that it ought to be compiling and the economic regulatory costs that it ought to be compiling. Nobody sees the same rainbow. We all look through different drops when we see it, and nobody sees the same cost and benefits of regulation. I use a lowball figure for the cost of regulation of 1.9, which OMB's numbers back at the turn of the century were over $1 trillion. There have been a lot more regulation since then, and these days, the NAM has a cost study on regulatory cost, annual regulatory cost of over $2 trillion. Mercatus has a new study with substantial costs for regulation. There's another study of the cost of regulation that would put cost over $50 trillion a year.
You're starting to dazzle me now. I just have one last question.
Good.
And I'll try to make it as clear as I can. Tom Donahue, the president and CEO of the Chamber of Commerce, is quoted as saying that we need, quote, end quote, many of the regulations included in your anti-regulatory report, and that they are important for the economy, and we support them. That's what Tom Donahue, CEO and president of the Chamber of Commerce, said. I want to know if you agree with that, and I want to get your comment about the fact that prior versions of your 10,000 Commandments report admitted that it was not scientific and it was back of the envelope. But that language did not appear in the most current version, the one that was given the 2 Pinocchios. And I wanted to know, why did you remove those caveats from the 2 Pinocchios 10,000 Commandments report?
I didn't remove them. It's still all in there. The 10,000 Commandments report is citing the Costberg figures where I have all of those disclaimers there. And I cannot go below those figures. Those are using largely government's own numbers for the cost of regulation, and then other compilations that are out there.
Well,
As for Donahue's,
you disagree with what Tom Donahue said?
yeah, as for what he said, 10,000 Commandments is not an anti-regulatory report, and the Competitive Enterprise Institute is not an anti-regulatory group. And the majority here is not an anti-regulatory entity. This is an OIRA hearing. We're talking about your job of reviewing the regulatory state and what the regulators who are not elected are doing. So that's the purpose of the hearing. But the 10,000 Commandments is not an anti-regulatory report. Your question is, what does the best regulation? Is it always going to be a political system that does the best regulation? Or do you need other kinds of disciplines that play a role?
Well, Mr. Cruz, you've been quite gracious in your responses, and Mr. Chairman, you've been quite gracious with the time. I'm way over the limit, and with that, I will yield back.
I have another question I'd like to ask, and if you would like to, thank you, certainly. Even I don't consider Professor Dreesen to be hostile, so this will pertain to you as well, sir. If you care to. Can you give me an end-of-term grade that you would assign to the Obama administration for its performance in regulating without inflicting unnecessary economic harm or imposing unnecessary regulations? Dr. Beach.
I'd give it a C minus or a D plus. I think the regulations which have been produced out of the recession, well-meaning as they were done without due regard for the cumulative costs and the effects on the enterprise system.
Thank you, Dr. Crew. Mr. Crew.
Well, I think looking at cumulative effects of regulations matter a lot, and even what Mr. Johnson said, what you've said about OIRA's role in looking at and reviewing regulations, I think matters a great deal.
Professor Dreesen.
Well, with the caveat that that's a really difficult question to answer, none of us here have read all these rules. I would say that the ones I know about seem sensible to me and look like an A. I've seen them going after things that really need the attention and seem to be doing it in a reasonable way.
Dr. Holtz, you can.
I guess I'm in the vicinity of a C, C minus. I'd say the break they deserve is that a lot of this comes from the Dodd-Frank Act and the Affordable Care Act, which were drafted very poorly by the U.S. Congress and have led to some real regulatory problems in filling that out. The thing I think they did most poorly was to not keep track of the breadth of the regulatory burden. That's been unusually active, not just at HHS and at the SEC and CFTC, but the Department of Labor, the FCC, the Department of Energy. Sort of every agency has issued regulations at a remarkable rate, and I think it is OIRA and the administration's responsibility to look at that and modulate its impact on the economy, and they did a bad job there.
And Mr. Cruz, did I not hear you give a grade? If I did not hear you, then my ear is as bad as my arm.
I did.
You did or didn't?
Yeah.
You did. I think, what was yours? I'm sorry.
I just said, I think the presentation of the there needed to have been a lot more review of regulations than there was, and I wish that we could use OIRA more effectively to govern that.
So is that an A, C, or an E?
I got to say a C because,
okay.
Yeah.
Now, one more thing I want to ask each of you to respond to. How important is the fact that we must look at the economics involved when it comes to job creation or job loss in regulation, if it's important in your opinion at all? Dr. Beach.
Well, yes, it's something we haven't talked about today, is the important to whom. And it's largely important to people who are low and moderate income. They bear a disproportionate share relative to their income of the cost of regulation. So when we impose well-meaning regulations and it does what it does, we need to keep them in mind. It's called regressive effects, and I think they're much in your mind in other areas as well. So.
Mr. Cruz?
One thing related to that, too, in terms of job effects of regulation, it'd be good to look at how regulations might stack up as a small firm grows. Mr. Trott had mentioned growing a business and had mentioned I couldn't do it today if I were setting out in this kind of a regulatory enterprise. Well, if we disagree about that, let's find out why we disagree about it. Let's look at what laws are taking effect as this firm hits 4 employees, 5 employees, 10, and 49, and see what adds up, and look at it from the statutory side and from the regulatory side, and see what kind of inventory we have of how these things stack up with a small firm grows and affects job creation and job growth.
Professor Dreesen.
I do not think regulation is a significant, at least over-regulation has not been a significant factor in causing job loss. Under-regulation has, because we legalized subprime mortgages, which were illegal at one point. We allowed large firms to get into the large banking firms. We dropped that got them into the subprime business. When they were separated, there was no problem. I can give you I can put an article to spell it out for you. So deregulation has caused a financial crisis. Regulation has a tiny effect on jobs, and in the environmental area, it's a small net positive. And we used to have statistics on this from the Bureau of Labor Standards, but Congress has defunded it. Now, what those statistics shows is that environmental public health and safety was about 0.2% of mass layoffs. mergers and acquisitions were a big cause of unemployment. And so if you're going to get serious about unemployment, you got to stop hammering away at regulation, refund BLS, and look at what's really causing it. And I don't think you're going to find regulation to be prominent among the problems with job loss.
Dr. Holtz-Eakin.
So, as I said, I think you should quantify everything you can so that you understand the comprehensive benefits and costs of a rulemaking process. But certainly, you should always place priorities on the most pressing issues. And in the past, from the end of World War II to 2007, this economy grew fast enough that even with population growth, the standard of living doubled every 35 years, roughly one working career. The projections are that this economy will grow only at 2%, and if you roll in population growth, that means the standard of living doubles every 75 years. I believe that's the primary domestic economic policy problem that we have, and that we should devote all of our attention in the regulatory, tax, and budgetary process to solving that problem.
Thank you. Mr. Johnson, do you have any questions?
Thank you. Yes, Dr. Beach, with respect to the assertion that you just made, and you also made it in your written testimony, that regulations disproportionately burden low-income populations and undermine economic productivity, and you said that citing studies conducted by the Mercatus Center. I just want to know from you whether or not the lead in the contaminated water in Flint was the result of over-regulation.
I'm not an expert on how it got there. I'm very concerned about it, as I'm sure you are as well.
Was it over-regulation that was one of the factors that
I'm not the best one to
contributed
ask that
to
question.
lead getting
No.
into the...
It could have been a number of factors. I'm not sure. It could have been the land. Who knows? I'm an economist.
It wasn't over-regulation, was it?
Well, who knows? I mean, it could have been. It could have been this. For example, if you have a municipality that has a lot of in a state that has a burden of a lot of regulation, that can undermine the tax base. If the tax base is undermined, you might not take care of your infrastructure. I've known lots of cities that have had poor infrastructure, which gets into things leaching into the water supply. So unless you or I are experts on how it actually got there, I could make an argument that, yes, it could have been because of over-regulation.
If there were no regulations, then, of course, you would have all kinds of contaminants in the water. Isn't that correct?
That doesn't necessarily follow.
So in other words, you're saying in an environment with no regulations, you're going to always have safe drinking water.
Absolutely not. We need the regulations which we have around the drinking water today. Yeah. They've been very effective.
And those regulations do not hurt or disproportionately burden anybody, much less low-income people.
Right. And so they in fact they benefit everybody. But my point is this: if you have a slow economy, if you have a slow economy because of a cumulative regulatory burden, then wages grow slowly in the bottom half of the distribution. Now, they, of course, benefit from the clean water just like the top half, but they don't have the benefits of the growing economy like the top half does.
Well, I mean, but you can have a couple of companies making a gazillion dollars, and then you have the consumers, the people who purchase the product or service, dying at an early age, as we heard someone say today. We got people dying at an early age. I mean, what is best? I mean, should we just have an unregulated environment and a free market system to let the buyers beware and let the companies do whatever they want to do, and there's no regulations?
I think we're past that, aren't we, Congressman? I've said in my remarks.
From what I'm hearing from the Republican witnesses and from the messaging from that side of the aisle is that we're over-regulated. All of these regulations need to be abandoned, and we need to get government off the backs of the business community so that they can make more money. And it doesn't matter the health safety of the people.
Of course,
it
health and
really-
safety matters a great deal, and
How
we
can you
are.
quantify that on a cost-benefit analysis?
Well, I think it can and should be done so that you have the best advice possible for making decisions, as you must make, between spending on A, B, and C. If you
Do you
didn't
think
have
the
cost-
regulators should have that?
I think we should
that
all
ability?
do. Yeah, cost-benefit analysis needs to be done in much more than it's being done now.
Well, I'm going to yield back the balance of my time, and I thank you all for your testimony. I'm sorry I didn't get to you, Mr. Dreisen. Thank you.
Thank you all for being here. This concludes our hearing, and without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials. For the record, the hearing is adjourned.